Doug, are you there? Okay, we're on the record. Good morning. My name is Kristen Lawrence. I'm a public utility law judge of the Public Service Commission of Maryland. We're here this morning in case number 9632. Which is captioned in the matter of the joint application of Chesapeake Utilities Corporation and South Jersey Industries, Inc. for approval of an agreement by which Chesapeake Utilities Corporation will acquire the Elkton Gas Company. We'll start with appearances by the applicants in this case. And if I think Mr. Quinn, you might have joined late, please unmute yourself when you need to speak and then remute yourself when you're finished speaking so that we avoid the feedback.
Did I unmute myself, I hope?
I can hear you.
Thank you, Your Honor. It's Brian Quinn on behalf of Chesapeake Utilities Corporation.
And on behalf of Elkton Gas?
Yes, good morning, everyone, and good morning, Your Honor. Carville Collins on behalf of South Jersey Industries and Elkton Gas. And I have with me today Deborah Franco, Director, Regulatory Affairs Counsel for SJI and Elkton Gas.
OPC?
Good morning. Good morning, Your Honor. Joseph Cleaver on behalf of the Office of People's Counsel. And I have with me Kevin O'Donnell, consultant for OPC.
And staff?
Good morning, Your Honor. Lloyd Spivak and Catherine Mackerlin for staff. We have with us this morning Olivia Kuykendall, Felix Patterson, and Adeshina Jayola.
Okay. Any preliminary matters before we get started? Counsel?
I don't believe so, Your Honor. I believe we filed some notices of publication recently for the public hearing that's forthcoming, but I don't believe we have any preliminary matters to discuss.
Okay, then we can get started with exhibits.
Yes, Your Honor. On behalf of the applicants, we filed yesterday, as you may be aware in the docket, we filed on May 4th, we filed the joint motion and unanimous stipulation and settlement agreement. And attached to that filing, we included the testimony of Shane Brakey in support of the settlement. Shane Brakey's here. I should have introduced him. He's a vice president for Chesapeake in this case, both in direct and rebuttal, and he filed settlement testimony on behalf of the applicants.
Okay, did you want to start with marking that, or did you want to start with the application?
Preferences, Your Honor. I mean, I can start by marking the application itself and go down the line there if you'd like.
However you want to have them marked and entered in. Number one, applicant exhibit 1 is already what you filed a few days ago, the notice of the pre-hearing.
Yep.
So wherever you start, you'd be on applicant exhibit 2.
Okay. Well, with your permission, Your Honor, I'll just start with applicants exhibit 2. And I'd like that to be the application filed in this case.
The application will be so marked. Is that just the application, or did you want the exhibits with it?
The application and all exhibits attached there too.
Okay, I have exhibit A, A-1, B, C, and D.
I believe that's correct, Your Honor. In addition, pursuant to the settlement agreement, we've also agreed to move in the direct testimony, the 3 pieces of direct testimony that were attached to the application. I can move those in individually or all with exhibit 2 if you want.
Why don't we mark those separately, please?
So applicants number 3 would be the direct testimony of Shane Brakey.
That'll be be marked as 3.
Applicants Exhibit 4 be the direct testimony of Thomas Mann,
So marked.
and applicants 5 would be the direct testimony of Christy McMullen.
So marked. And I believe all of those will be entered by stipulation, correct?
Yes, ma'am.
Okay, applicants exhibits 2 through 5 are admitted into the record.
Next, Your Honor, I believe we'd go to the rebuttal testimony on behalf of the applicants.
6, would you like that marked as exhibit 6?
Yes, ma'am. Applicant 6 would be the rebuttal testimony of Shane Brakey.
So marked.
Applicant 7 then brings us to where we are today, would be the joint motion and unanimous stipulation and settlement agreement.
The motion will be marked as applicant exhibit 7.
And Your Honor, that includes the stipulation and settlement agreement with the motion. And finally, applicants 8 would be the testimony of Shane Brakey on behalf of the applicants in support of the joint motion and stipulation settlement.
That is so marked, and by stipulation, applicants exhibits 7 and 8 are also entered into the record.
Thank you, Your Honor. I'm all out of exhibits right now.
Okay. OPC, would you like to enter your exhibits at this time?
Yes, Your Honor, thank you. OPC would ask that the direct testimony of Kevin O'Donnell filed in this case on March 20th, 2020 be marked as OPC Exhibit 1.
So marked.
And OPC would next ask that the settlement testimony of Kevin O'Donnell filed in this case on March 4th, 2020 be marked as OPC Exhibit 2.
So marked.
And we would ask that those 2 testimonies be entered into the record in this case.
Those 2 exhibits will be entered by stipulation. If we could, Mr. Quinn, I'm sorry, I apologize. I need to go back to what has been entered as applicant exhibit 4, Mr. Mann's direct.
Yes, ma'am.
Just one, I believe, correction to that testimony. At page 7, he cites to Comar 20.40.02.07. I believe that should be 20.40.02.08.
What page is that, Your Honor?
Page 7 of his direct, exhibit 3.
I've got no reason to believe you're incorrect, Your Honor, but I'm sure you're right.
Well, if you're sure I'm right, we'll make that correction.
I just don't have the Comar in front of me, but I can check.
You know what I can do? Would you like me to do that?
Sure.
Give me just a second here. I don't want you to go based on what I say.
Your Honor, I'm with you, and I believe 07 is the CAM regulation and 08 mentions ring fencing, and Mr. Mann's testimony refers to ring fencing.
Yes, that's why I thought it needed to be changed to 08.
I knew you were right.
Okay. It was going to take me, it's going to take me a minute to pull it up, but
Thank you, Judge.
that's fine. Okay, sorry, we'll go to staff. with staff's exhibits.
Okay, good morning, Your Honor. Staff would like to mark the direct testimony of Felix L. Patterson as Staff Exhibit Number 1, please.
So marked.
The direct testimony of Staff Witness Olivia Kuykendall as Staff Exhibit Number 2, please.
So marked.
And the direct testimony of Staff Witness Jayola as Staff Exhibit Number 3, please.
So marked.
Also, we have the rebuttal testimony of Olivia Kuykendall. That should be Staff Exhibit Number 4.
So marked.
And the settlement testimony of Staff Witnesses Kuykendall, Patterson, and Jayola testifying jointly as Staff Exhibit Number 5.
So marked. And by stipulation, staff exhibits 1 through 5 will be entered into the record.
Thank you, Your Honor.
Thank you. Okay. I had a couple questions for Mr. Brakey.
Yes, ma'am. Mr. Brakey is available to be sworn, and I believe he's on the line.
I am. Good morning, Your Honor.
Good morning, Mr. Brakey. Can you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth? Thank you. Mr. Brakey, in your rebuttal at pages 1 to 2, you testified that Mr. O'Donnell's recommendations or his recommended conditions would severely and negatively impact Elkton Gas's customers. I believe you clarified in your settlement testimony at page 4 that there were only 2 recommended conditions that you were concerned about, those being the $100 rate credit and the 4-year stay out provision. I wanted to confirm that those were the only 2 items that you believed would severely and negatively impact Elkton Gas's customers. Can you confirm?
They were. Yep.
With regard to the rate credit, you testified that a rate credit as proposed by Mr. O'Donnell of $100 would be approximately $700,000 total. In this settlement, you've agreed to, on behalf of Chesapeake and Elkton Gas, the settlement amount is $301,983.45 over 2 years, which is approximately $150,000 per year. Do you know, is that approximately 1/3 of Elkton Gas's annual net income?
Yes, their annual net income is, I believe, approximately around $600,000. So maybe 1/4.
And at page 5 of your settlement testimony, you indicate that this is a compromise. But is that an amount that will not negatively impact, excuse me, I don't know, there was a little bit of interference there, I'm sorry. Is that an amount that will not negatively impact Elkton Gas's customers?
It will not negatively impact Elkton's customers, correct?
With regard to the stay out provision, you agree that the longer Elkton Gas stays out, and that is colloquial for not filing a base rate case, the higher the jump in rates when Elkton Gas eventually does file a base rate case, correct?
Correct.
Do you have an estimate of the rate increase that Elkton Gas will seek when it files a rate case per the settlement after February 7, 2022?
Oh, I don't at this time. No, I apologize.
At page 10 of your rebuttal, you talked about the need to file a rate case based on expected normal and customary increases in expenses. And then you said those would be added together with this major capital investment of the pipeline remediation plan.
Yes.
And at page 8 of your rebuttal, you refer to the pipeline remediation plan as a $6.364 million investment. Do you
Yes.
recall that testimony?
Yes.
And you also indicate that that amount, the $6.364 million, is approximately 69% or represents an approximately 69% increase in the company's rate base.
Correct. Yep.
And at page 5 of your settlement testimony, you testified that if Elkton Gas only has to stay out an additional 6 months, Elkton Gas will still be able to implement its current pipeline remediation plan. Do you recall that testimony?
Yes.
Do you know how Elkton Gas has been financing the pipeline remediation plan?
They are not currently using the STRIDE program, and they are under a current stay out provision at this time. I believe they did go in for a rate proceeding, and Brian, you can probably attest, maybe 2 years ago. But beyond that, I'm not aware of how they're currently financing it.
Going forward, Chesapeake will fund capital investments such as the pipeline remediation plan, correct?
Yes, that's correct. Yep.
And how will Chesapeake fund the pipeline remediation plan?
I mean, there's, you know, Chesapeake has a strong financial backing. There is still the STRIDE program that if we can accelerate the replacement program, we will see if the STRIDE program will be a way to seek recovery. And, you know, after that, there is the potential to come in for a rate proceeding once the stay out is over.
Okay, but in the meantime, is Chesapeake borrowing to fund the capital investments?
I wouldn't say we're borrowing, but we will not be meeting our return.
Okay, so there aren't financing costs associated with making the capital investments required by the pipeline remediation plan?
Yes, inherently there are. You know, I would have to defer to Tom Mann, who's on the call on, you know, those specific mechanisms.
Okay, well, the settlement agreement at page 6, paragraph 6, can you explain what is meant by the statement, the financing costs of investments in Elkton Gas's ongoing operations will be recoverable in utility rates?
I apologize. You said page 6.
Yes, page 6, paragraph 6.
I don't know why I'm not seeing that. I apologize.
Hold on.
The settlement agreement, Shane, not your testimony, in the settlement agreement itself.
I apologize. I don't have that here. I'm sorry, Your Honor. Could you say it one more time?
Well, I was going to try to pull it up if I could.
Okay. Were you going to pull it up on your screen or?
Yeah, sorry.
No, it's all right. I wasn't sure.
Trying to share the right thing here. All right, do you see it now?
don't.
You see my screen?
At the moment, all we're seeing is a black screen, Your Honor.
Oh,
Yeah,
that's unfortunate. Okay, then I'm gonna stop share. I don't know
okay.
why it won't share my
Yeah,
screen.
We're
Let
all
me
learning
stop.
here.
Yeah. Um,
But our standard financing is through a mixture of equity and debt. And I without having it in front of me, we do have yep, we can see it now.
oh, okay. Um, so it's the second sentence of paragraph 6. The financing cost of investments in Elkton Gas's ongoing operations will be recoverable in utility rates. So what I was trying to determine was what those financing costs would be that this settlement proposes will be recovered in Elkton Gas's rates.
So when we file our next rate proceeding, those financing costs could be a mixture of equity and debt. It's our standard way of financing.
I guess the interest, are you proposing that the interest and carrying costs going forward, or just those in the test year?
I guess it depends on how we file. If it's, I believe going forward, but I'm not sure how we're going to be filing at that time.
The original pipeline remediation plan was 2018 through 2024. Do you know
Right.
how far along Elkton Gas is with the pipeline remediation plan?
We've been told that they're on schedule at the pace to have it complete by 2024. As far as a percentage of the total, I'm not fully sure, but our intent is to finish by then or possibly even earlier.
Okay, would it be accurate to say that Elkton Gas will be at least halfway through by February 2022, which is the earliest it can file a rate case in terms of the
Half,
settlement?
I mean, they're 2 years into it, I believe.
Right. You said they are committed to finishing in 2024.
Hmm.
So that's why I was wondering if they'd be about halfway by February 2022.
I believe they're a little bit less than half, but it's around
Less
there.
than half now or by February 2022?
Oh, right now.
Less than half now.
Yeah.
And you don't know
By
where they'll be
February.
by February 22?
No, I don't. Not right now. No. But again, our intent is, of course, to honor that and potentially get it done even sooner.
In your rebuttal testimony at page 5, you testified that the overhead expenses of Elkton Gas post-acquisition are projected to be in line with current costs. Have
Yes,
you reviewed OPC Exhibit 2, which is Mr. O'Donnell's settlement testimony?
I did. Yes.
Okay. He has a table in his settlement testimony, table 2.
And I apologize, I don't have it in front of me, so
Okay. Do you need me to pull it up?
yeah, if you'd like, if you don't mind.
I don't mind. It just takes a while, as we learned. Let me know when you can see my screen, please.
It's still dark at this time.
I'm not sure why that delay.
If you like, Honor, let me give it a try. It worked the last time.
Okay. Oh, is that what happened? You shared it?
Yes.
Oh, excellent. All right, let me stop sharing. And if you can share it. I apologize. I don't know.
Okay, hang on. Okay, this is Mr. O'Donnell's testimony. What page was it?
Well, it's table 2. If you scroll down, we'll. There we go. No, that's 1. Sorry. The next one.
Here we go.
There we go. Thank you. Mr. Brakey, do you agree with the figures in Mr. O'Donnell's table 2?
Yep.
I calculated a 2.6% increase in total O&M expenses between 2019 and year 1 post-merger. Does that sound right?
That sounds right.
And is that what you meant by inline?
Yes.
Thank you, Mr. Spivak.
Okay.
With regard to the ring fencing provisions, in rebuttal at page 5, you testified that the ring fencing provisions proposed by Mr. O'Donnell, actually the one provision that Elkton Gas not commingle funds with Chesapeake or its affiliates, that provision in particular would harm Elkton Gas's customers. And then in your settlement testimony at page 6, you state, as a whole, the ring fencing and financial integrity protections included in the settlement agreement demonstrate that the acquisition is in the public interest and will not harm Elkton Gas customers. Just to confirm, the only ring fencing provision that you believe would have harmed Elkton Gas customers did not become part of the settlement, correct?
Correct.
I see you nodding, Mr. Quinn. I don't
Oh,
know
is
if he can, I don't know if he can see you, but I can see you. So,
I'm sorry. I missed that. I apologize.
no, you should have missed
I'm
it. That's okay.
Sorry, Your Honor. Keep my head still.
There we go. Mr. Brakey, did the applicants expect there to be any synergy savings realized as a result of the acquisition?
No.
So paragraph 7 of the settlement is fairly meaningless.
Of the settlement.
Yes. Oh, is that the one you don't have?
Yeah, I apologize.
The one that talks about synergy savings and amortizing the cost to achieve so that they wouldn't be recovered if they are greater than the synergy savings. Recall that provision.
Yeah. So, yeah.
Are you saying yes, that provision does not have significant meaning in this case?
Yes.
Okay, Mr. Brakey, thank you for your testimony this morning.
All right. Thank you.
Mr. Quinn,
Yes, Judge.
paragraph 33G of the settlement.
Yes.
I'm just trying to understand. If I changed one term of your settlement agreement, but entered a proposed or issued a proposed order that contained all the other terms of your proposed settlement, the parties would be able to appeal not only the one term that I changed, but the entire proposed order at that point?
You're in G, Your Honor.
Yes. I hope I'm in the right place.
Okay. I thought G applied to the commission changing a term. But
Tell me what happens if I enter a proposed order that changes one term.
If you enter a proposed order that changes one term, I'm not sure.
Otherwise contains all of the other
Yep.
elements of this settlement agreement. What happens?
I'm not sure that eventuality is even captured in the agreement. But I could be wrong.
Well, look at B.
G was, I'm sorry?
Look at B, 33B.
Yep.
So the commission has to accept all of the terms.
Subject to 33G. And
And G says if the commission doesn't grant approval of all of the terms and conditions without modification, the agreement will terminate and be of no force and effect.
unless,
Unless you agree in writing to waive. Yes, I'm assuming. Okay, what I'm wondering is, say you don't do that, you don't agree in writing to waive application provision, or one of the parties doesn't, right?
yes,
Would that party or any of the parties then be able to appeal all elements in the proposed order, or only the one element that was modified?
I believe the language was intended that if all parties don't, unless the parties unanimously agree to accept the change in the settlement agreement, then the entire agreement's null and void. So I'm not sure they'd be appealing anything. The agreement would be null and void.
That's where I guess my question lies, because I intend to issue a proposed order. And it's not just merely granting your joint motion for a settlement.
Yes, ma'am.
It's a proposed order on the merger itself or the acquisition. So it's a little bit, I'm sort of questioning you because it's a little bit of a pet peeve of mine, this G language that is in every settlement, that we have to accept every condition or otherwise the whole deal's off. But in this case, what I'm saying to you is, I don't think that it does you, I'm going to go ahead and either approve or disapprove the acquisition. And you can appeal that order. And at that point, it doesn't matter whether your agreement is null and void or not, correct?
Your Honor, might I speak to the point?
Sure. Mr. Spivak, go ahead.
I think, Your Honor, if you were to issue an order that approved everything except one provision, that provision would nonetheless go into effect. That is, the settlement would be null and void. And at that point, the parties are left with their litigation positions. So, it would be probably the parties, they would have a choice as to whether to leave all of the other settlement provisions in place and, abide by the former agreement, or appeal the whole thing and ask that the commission implement their litigation position. So I think at that point they're kind of left with no choice but one or the other as well, or to accept whatever condition, whatever modification you seek to make.
Okay.
Your Honor, if I could, this was a topic of discussion between staff and the parties, and your pet peeve is a issue we discussed amongst ourselves, and that was the impetus behind 33G in the first place. We understand that no law judge or the commission likes to, the all or nothing language, and in fact, this was an attempt to address that somewhat poorly. I seem perhaps, but that was the intent, was to allow the parties to continue to have the choice to continue on or not unanimously if a change is made to the agreement.
That's correct, Your Honor. I mean, we were seeking to leave that out because it's quite possible that any change you seek to make would be perfectly acceptable to the parties. So that's why we had that provision in there.
Okay, we can move on. I just wanted to go over that. I also have a couple of questions for Mr. O'Donnell. Good morning, Mr. O'Donnell.
Good morning.
Can you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Regarding ring fencing provisions, in your settlement testimony, the ring fencing provisions, you testified that the ring fencing provisions in the settlement agreement are sufficient to protect Elkton Gas customers from risk of harm as a result of the acquisition. Is that your testimony?
Yes, it is.
Mr. O'Donnell, what is the purpose of a stay out provision?
A stay out provision is to essentially give customers a break from further rate increases, and to give them a little bit more benefit from the rate case merger provisions that would be involved in the merger details, I should say.
You mean if there were merger savings?
Exactly. I mean, well, to the extent that they would otherwise increase rates in a rate case prior to the stay out, and that extra time gives customers some savings in the meantime.
Okay. But you heard Mr. Breaky's testimony that the applicants and Elkton Gas do not anticipate any merger savings.
I did.
Okay. So you said the other purpose of the stay out provision, and correct me if I'm misstating your testimony, was to give customers a break on a rate increase. Is that what you said?
Yes, I mean, to the extent that you have a rate increase between now and the end of the stay out provision, then those are savings. I mean, for example, if rates were going to go up 10%, but because of the pick a time period, suppose that the rate increase would take effect on January 1, 2021, for example, and the stay out provision goes through the end of July, then that's 7 months of a rate increase that the customers would not have to pick up.
Okay. But doesn't the longer a company stays out, the longer they wait to file a base rate, doesn't that make the one-time jump of the eventual rate increase worse?
It could, but there are ways to mitigate that. I mean, for example, phasing in the rates over a period of time. There are different ways that we can deal with that down the road. One thing, however, is known is that those extra 7 months in that example I discussed, those are definite savings to the consumer. But we can deal with the rate increases as they occur down the road by phasing it in. But I won't argue your point. I mean, it is clear that the longer that they stay out, there could be an increase in rate base. But again, I think there are ways we can mitigate that.
Your settlement testimony indicates that you would have preferred to review the CAM prior to closing, but you state that applicants have produced information concerning projected costs that alleviated your concerns regarding the allocated overhead costs. Recall that testimony?
Yes, I do.
So you would not anticipate that the CAM would reflect a material change from the projected overhead costs?
No, I don't. And I do know that OPC did submit a rather detailed data request in this case in regard to those costs. And we do have that as part of the record so that when the next rate case comes up, we will be comparing the various costs relative to what we see in this data request response, and maybe taking action, maybe submitting testimony if we don't agree with the way the costs are being reflected in the company's rate case filing.
And I'm sorry, for the record, CAM is cost allocation manual.
Yes, it is.
That's all I had for this witness. I don't believe anyone has the ability to ask questions at this point pursuant to the settlement. So unless there are any further items, Mr. Quinn is shaking his head no. Mr. Collins,
No, Your Honor.
thank you. Mr.
Your
Cleaver,
Honor, I do have just one question for you, having to do with our schedule going forward, if this is an appropriate time to raise that.
sure, certainly, go ahead.
If in of the unanimous settlement, just a question regarding your thoughts about any appeal period, and might that appeal period be shortened in light of the parties all being on board here? We had set the customary and usual amount of time in the schedule for appeals of the proposed order. We do not anticipate that in this case. So would Your Honor be considering any shortening of the appeal period to more along the lines of the minimum time period rather than what I think we had built into the schedule?
Well, I don't know that the commission wouldn't use the time allotted to them. What I can do, though, is tell you that I don't intend to take all of the time in the schedule allotted for me to issue the proposed order.
Okay.
Which then by rule will, I believe, push up the time, since you've, there's going to be no appeal pursuant to the stipulation. If the proposed order approves the settlement, that would mean that 30 days from the date I issued the proposed order, that the commission had to, sorry, I'm trying to find out who's coughing and who I have to mute.
Yeah.
So,
I'm sorry, could you repeat that, Your Honor?
yes. So if I don't use all the time allotted to me to issue the proposed order, and if the proposed order doesn't change any terms of the settlement such that the parties have waived their rights to appeal, doesn't that mean the commission has 30 days from my proposed order to issue a final order?
Yes, that would be usual.
So I think there's a chance you'll get where you want to go that way, but I don't know if you want a modification of the procedural schedule other than what that would allow.
I would only do it if the other parties would be comfortable. Perhaps I would suggest for the parties' consideration if we might all agree to shorten the appeal period to a 14-day time frame, which I believe is the minimum.
So in the event the settlement is not approved, the parties all agree to a 14-day appeal period?
We can agree to that with a further 14 days to do a memorandum on appeal.
So 14 days to file the notice of appeal, and then an additional 14 days to file the memorandum on appeal?
Actually, that would be 10 days, I believe, actually, because that's the time between the notice and the memorandum normally. So 14 days and then 10 days instead of 30 and 10.
And no reply?
Your Honor.
Yes, Mr. Cleaver.
You know, as Your Honor, I'm sure recalls from the initial procedural conference in this case, there was the issue of obtaining an extension to the standard, I believe it was 45 days, and Your Honor had asked the parties to file a motion with the commission.
Yes.
And the entire schedule kind of is premised around that final commission deadline, and we kind of work backwards. So I'm not sure if I'm following this conversation in terms of where it's going or what the goal is. I mean, I think that if the desire is to speed up the entire regulatory review process in light of the settlement, it sounds like, unless I'm missing something, that we would actually need to first start with the commission itself and ask for some, I mean, I haven't given this much thought, so I don't want anyone to construe this as my agreement to this idea. But it seems like we would have to start with the commission to file something. Basically, it'd be like a unanimous request to reconsider the earlier or withdraw the earlier request to add the period at the end of the deadline, and then go backwards from there. I mean, we can all agree to different appeal periods, or Your Honor can, you've expressed your intention to get out your order earlier, your proposed order earlier than July 2nd, but I think we're still left with that deadline that from the commission that's the result of a motion that we all filed in terms of when the ultimate approval will come.
The commission's final order in the case, there's an outside deadline by which the commission has to make that, and regardless of whether we, the parties and/or the judge, modify the appeal period, the commission is still only bound by that final date, and there's nothing we could do to change that without going to the commission directly and asking them. So on that, you're correct.
So back to Mr. Collins, I had said that if I got, if there was a proposed order that accepted the settlement completely, such that parties waived their rights to appeal, Mr. Spivak disagrees with your statement that the commission would have to get the final order out in 30 days, and he believes they would have all the way until August 20th. And I guess what I said initially was, I'm not sure I can do anything to speed up the commission in taking all the time that they are granted. You can try to, you can always file a motion if you'd like, but Mr. Spivak may very well be correct that even if I get the proposed order issued sooner, they don't need to file a final order sooner.
And no objection, Your Honor, to any of this discussion. My purpose was simply to shorten the time that it would take to get the proposed order to the commission for its review, and therefore give the commission an opportunity to issue its final order in advance of that final outside deadline of I think 215 days. So not trying to dictate either to Public Utility Law Judge Division or the commission, just trying to see if we could shorten the time frame. It would give the commission more time, and it might produce a final result, in this case, a little bit earlier than the outside 215th day on our original schedule.
Understood. It might, if the proposed order again accepts all the terms of the settlement in full, and if the proposed order does not accept all the terms of the settlement in full, but I still get it issued sooner than July 2nd, the parties will have more time to file their memoranda on appeal. So I think we'll proceed that way. Anything else? Seeing nothing else, thank you everyone for your cooperation and participation in today's hearing. And we are adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Take care.